Let's go ahead and get started again. So before I begin the panel, I wanted to give a few other thanks. I was planning to thank people at the end of the day, but some of you may not be here to hear it, and I wanted to just make sure to acknowledge there's an incredible team here at Boston College that puts on these events, and they do it, and I'm not even sure how they manage to do it because we have so many events going on every week. But it's Joan Manna, Judy Yee, Wayne Daly, who you've seen working on audiovisual, and Nate Kenyon, who does our media. And also wanted to mention Alex, my RA, who's been pressed into being our technical support today, but he's already just run off, probably suspected I was going to say this. But I wanted to thank them for doing that. And to mention there's a literature table in the back with a variety of free literature, some about this project that we're working on. All right. Including some copies of the third-party funding draft report that is the subject of our panel right now. So welcome to the second panel in our event on third-party funding in investment arbitration, or TPF as it's often called. I want to mention that this panel is also a public comment event for the draft report of the ICCA Queen Mary Task Force on third-party funding in international arbitration. And we're very fortunate to have Rusty Park here with us on the panel, who is the co-chair of that task force. A written summary of your comments today will be submitted into the process. October 31st is the deadline if you want to comment individually further as well, and there's information on the ICCA website about how to do that. Rusty's joined by our keynote speaker today, Dr. Eric de Brabander, who was graciously agreed to step in when one of our original panelists was unable to come because of a family emergency, was Narghis Torres from LexFinance, one of the finance parties that works with these arrangements. And they are joined by Rachel Thrasher, a research fellow from the Pardee Center at BU, and Leo Gargne, a graduate of the Sorbonne and currently an LLM student here at BC, whose master's thesis was on TPF in commercial arbitration and is currently doing research on extending that work into investment context. Now, although TPF, which we could say just colloquially would be dispute funding as an investment by non-parties, although TPF has only recently been on the upswing and was for a long time illegal in most common law and civil law jurisdictions, it has already generated a lot of interest and controversy in its short but meteoric rise. Today we have the opportunity not only to consider and evaluate the task force report as a response to both the opportunities and risks of TPF, but also to consider TPF itself in the larger context of the future of international investment law. What role does it play, and what role should it play if we look at investment law from a fairness and governance perspective? So I believe, Eric, you're going to be going next, is that, or Leo? Leo, okay, great, thank you.
Good morning, everyone. First, I would like to thank the organizers of this conference, and specifically Professor Garcia for inviting me on this panel. I'm very grateful. Thank you very much. Now, turning to my presentation, as stated by the E20 Task Force on Investment Policy launched by the International Center for Trade Sustainable Development, the current ISDS system conceptually suffers from a tension between its public governance functions and its setup as a private dispute settlement mechanism that is modeled on the commercial arbitration model. And the effect and impact that TPF has within the investor-state dispute settlement system is only another illustration of this misalignment. So as was stated earlier this morning, the main goal of investment treaty arbitration is to provide claimant investors with a neutral and independent forum where arbitrators decide where a state has breached its treaty obligations. And this is often seen as a more effective way than having direct recourse to the host state's domestic courts, which may be biased and may not create a level playing field in terms of bargaining power. And so in that sense, ISDS also allows for a certain depolitization of dispute settlement as exercising diplomatic protection is not necessary anymore. However, there is a growing consensus about the need for reform with regard to the ISDS system, and it is primordial to ensure that states have enough policy space and have enough control over the proceedings and over the system as a whole. Past disputes in investor-state arbitration reflect how the balance has tilted in favor of investors, and what we see today is a substantial asymmetry as many BITs allow investor protection even though there exists legitimate governmental concerns and social values at stake. So how does third-party funding come into play in this context? And first of all, what is TPF, third-party funding? It is the mechanism through which a funder is going to fund a case either for a credit restraint claimant or an risk-adverse claimant with the expectation of receiving an uplift or return in case of success. In that context, it appears that TPF, despite its advantages in commercial arbitration or domestic litigation, might play a negative role in this legitimacy crisis that we've talked about within the ISDS framework, as it tilts a little bit more still the balance in favor of the investor. And indeed, the impact of third-party funding is certainly different in a system where one party, the respondent state, acts as a sovereign entity and is accountable towards its citizens and its government. So funders are usually very attracted to international investment arbitration under the ICCA Convention, as the quantum of investment treaty claims are usually highly significant, and the ICCA Convention provides certainty and efficiency as to the recognition and enforcement of the awards. In principle, third-party funding is also available to respondent states. However, due to the fact that funders are profit-driven entities, and because state cannot bring counterclaims generally in investment arbitration, funding states is much less appealing to third-party funders. Further, it might be tricky for the state to justify itself to its constituents as to why it has to pay the third-party funder an uplift, even in case of success. And most importantly, a funded state will have to give up some of its control over the management of the case and over the arbitration strategy, which is quite problematic. So in the present presentation, I will first address the tension that exists because of the growth of TPF between an increase in the volume of arbitral cases with potential negative impacts on the state's right to regulate, and an improvement of access to arbitral justice on the other hand. I will then turn to the implications of allowing a potentially non-disclosed third party to the table. So third-party funding is often seen as granting greater access to justice to impecunious or risk-adverse claimants, and consequently, it allows for a higher volume of cases to be brought before arbitral panels. While this would be something to be pleased if all additional proceedings brought before arbitral panels were meritorious, nothing is less certain, and in fact, the higher volume of cases may lead to an impingement of the state's right to regulate. With regard to the access to justice argument, it is important to note that given that most third-party funders are profit-driven entities, they have no interest per se in the substantive issues presented and discussed by the arbitral panel. Consequently, they are more likely to invest in claims having the potential for high-volume awards. And indeed, there is no empirical evidence that small investors, compared to big companies, do actually benefit from this form of financing. Therefore, and as Rachel will mention later, the access to justice argument needs to be questioned, especially since other mechanisms with the same purpose of protecting the investors are available, such as political risk insurance, for instance. Further, the assertion that third-party funding does not bring more frivolous claims because of the due diligence and screening process that funders go through before financing a claim seem to only reflect a partial economic reality. In fact, funders usually adopt the same business model as insurance companies and often form a portfolio of cases. Having several strong cases in their portfolio might enable the funder to adopt a more speculative attitude and undertake risk diversification strategies. That way, the funder can try his luck and with a weaker case for higher profit, for instance. On the other hand, there is a very real potential for an increase in the number of international investment cases, which could have a very significant and negative impact on states, and developing states more specifically. Damages awarded in investor-state disputes are colossal, and even if the claims are rejected, the reputation of the host state as an investment-friendly and secure jurisdiction for foreign investment might be tarnished. But more importantly, there is no general rule on how the costs of the proceedings should be allocated, and therefore, even if the state wins, it might have to pay for the cost it incurred to defend itself. Indeed, even before the case is decided or a final settlement is reached, the parties to an investment arbitration are going to incur costs. They are going to have to pay for their lawyers, the arbitrators, witnesses, experts. Very often, players in this process are located in different parts of the globe, and will have to they will have to pay for travel expenses or even translation services. So even if the American rule, applies, or even the German rule to some extent, in terms of allocation of costs, the state will have to bear some of these costs, which has a deterrent effect. What is also likely to result from this is a readiness to settle early by states, often in favor of the claimant, in order to avoid incurring substantial procedural costs. And given the nature of third-party funding, these settlements are likely to be of a pecuniary nature. Even if the state decides not to settle, an inflation of those costs might occur because of the investor's speculative behavior, because it knows that in case of success, the larger the award, the more compensation it gets to keep. So this increase in costs and its potential deterrence effect has to be seen in light of an essential asymmetry in the ISDS system, which is that the state always plays the role of a respondent and usually cannot bring counterclaims. This might not be the case when the investor and the state signed a concession agreement, but it usually is when the state gave his consent to investment arbitration beforehand in a BIT. So this entails that the funder always gets paid from the respondent states, and therefore, as stated by Professor Shannon, in essence, states are the sole payers in a system of third-party funding for investment treaty arbitration in which they are enabled to enjoy a benefit equivalent to investors' benefits. This is quite problematic in another respect, which is that the state's revenue and the state's money comes in large part from tax revenue, and allowing third parties to have an effect on the amounts paid is quite problematic, because in international investment arbitration, the state acts as a sovereign capacity, and they have to answer to their constituents. Therefore, and as a consequence, there is a serious risk that third-party funding will impose a significant burden on states, and indirectly has a chilling effect on any attempt at regulation based on legitimate policy concerns. In this respect, third-party funding is not the cause, but only reflects a systemic issue in the ISDS system. The legal norms and standards contained in most BITs are often read inconsistently and broadly enough so as to include regulatory measures within the ambit of investment protection. This is certainly not in line with the initial purpose of investment treaties, that is sustainable economic and social development, and the stimulation and the injection of FDI into developing and transition states in order to promote economic growth. And this goal, as we see today, it's not the case anymore, and the system does not work in that sense and in that way anymore. So now I'm going to turn towards the second part of my presentation, which is the consequence of allowing a potentially non-disclosed party to the table and the implications of such participation. Funders are not parties to the investment arbitration, strictly speaking, but by offering financing, they gain control and economic power over the claim and its management. They can influence the case and ultimately the outcome of the case, and this certainly poses a threat to the legitimacy of the arbitration proceedings with regard to independence and partiality of arbitrators, but I will not talk about this in this presentation. Further, there is a very real possibility that TPF has a bearing on states' obligation and on the contours of the law as it stands. It is essential to ask whether TPF might modify the law by bringing more marginal cases with new and novel issues that haven't been discussed before, And this is to be seen with regard to the frivolous aspect of the new cases that can be brought before arbitral panels as well. Given the broad standards involved in investment arbitration, this outcome seems very likely. And it is illustrated by the fact that, however seldom it might be, some funders have engaged in not-for-profit financing. And one of the reasons motivating funders to finance such cases, because they are still profit-driven entities, is to create a favorable precedent that would favor them in future disputes. A very good example of this is the case Quasar de Valores versus the Russian Federation under the SCC. And in that case, the funder, which was Group Menatep Limited, a former majority shareholder in the company UCAS, they did not have a funding agreement in that case, and the funder did not expect an uplift in case of success, which proves the point that not-for-profit financing does exist. And in that respect, one other question arises, which is that of whether the state's development is a factor in the third-party funder selection process. And the same question arises when considering the state's experience and expertise in defending itself against investors' claims. And a very good example of that is the Czech Republic, which only managed to win investment cases after having made the decision to hire elite international law firms, which are obviously very expensive. So, to conclude, third-party funding and the effects it has upon investment arbitration are simply evidence, if not symptoms, of a larger structural and systemic issue. Investor-state arbitration was not designed to help big multinational companies challenge states for trying to implement legitimate, non-discriminatory, and adopted in good faith measures regarding tax, the environment, labor, or even human rights. Some players have taken advantage of these systemic deficiencies within the ISDS framework. It is not to say that they are to blame for being economically aware and opportunistic, but simply that reform is needed and that both investors and states cannot be stuck in their respective roles as claimant and respondent anymore. There is a troubling lack of obligation on the investor's end in the system today, and even if the legal standards contained in most BITs have been applied differently depending on the arbitral panel, we see a general trend emerge, which is that of very liberal, expansive, and pro-investor interpretations of the legal standards set out in investment treaties. There is certainly a need for reform that would bring back international investment arbitration to its roots, which have more in common with public law litigation than purely private commercial litigation or arbitration. Balance between the parties, coherence in decisions, and integrity in the proceedings is certainly the way to go. And with regard to third-party funding, it seems that an absolute ban or an outright ban is not a realistic option. However, it is paramount that some form of regulation limiting the number of cases, of funding cases, be adopted. The legitimacy of the system is at stake. Thank you very much for your attention.
Okay. Thanks to Frank. Thanks also to Sebastian for having invited me here. I have a bit of a difficult task because I sort of jump in at the last minute to replace a colleague who couldn't make it. So I also agreed to be a bit more limitative in what I will say. The idea is that I will focus a bit more on the question of disclosure of third-party funding agreements. I know we will also discuss a bit later on questions of transparency, so I'll be very brief on transparency in general and focus a bit more on the precise question of disclosure. Now, it's true that we have seen over the past years a relatively impressive increase in the use of third-party funding. There's also a sort of increase in the tendency to try and regulate third-party funding. We have the TTIP, which has an article on third-party funding with a definition. The European Union, generally, more specifically the Commission, when it negotiates new investment agreements, is very keen on including something on third-party funding. I'm not entirely sure that the regulation they propose is the best. The main idea of what they propose to basically say you have to disclose it, but there's no sanction to non-disclosure to start with, so I don't think it's very efficient. The second reason is that they have this tendency to be very much against the idea of third-party funding, the European Commission, which at the same time contradicts a bit the idea that they also want to open up investment arbitration to small and medium enterprises, which is one of the most important points in the policy proposals that the European Commission made. And we all know, of course, that for small and medium enterprises, it's actually quite difficult to engage in investment arbitration if you have no funding outside. So my general idea, before I turn to disclosure, is that I think it's very difficult to regulate third-party funding. It's also very not really regulated in much detail in commercial arbitration. I think for investment arbitration, it's also very difficult to come up with a sound regulation, with one exception, this disclosure. So I'll focus on the question of whether or not it should be disclosed. And why I focus on this is actually the result of a discussion I had 4 or 5 years ago when I first presented this idea in a conference in Vienna. The first question I had from someone, a practicing attorney, is to tell me that it was completely outrageous to request disclosure because of the negative effect it has. And he said, I once did this, and I know this because I'm a practitioner, and implying that I was a mere academic without any practical experience, which he didn't know at that time, but anyway, that there are so many negative consequences, that it prolongs the proceedings, that you have security for costs, that there's a negative perception on the financial stability, the financial situation of the claimant, that it should actually never be disclosed and be kept secret. I think, on the contrary, and there are a couple of recent cases that actually support the idea that you can no longer keep third-party funding agreements and investment arbitration completely secret. Again, there's one general tendency towards transparency, which I will not discuss in detail. I do think that the notion alone of transparency as such is not sufficient really to, not only sufficient to ground the idea that you should disclose third-party funding agreements. I think you need something more, and this something more is what I'll discuss now. At the same time, there are several tribunals which have actually, based on the general principles of transparency, ordered disclosure of third-party funding agreement, and Insat Industry versus Turkmenistan is one example where they explicitly invoke the need for transparency. My main problem, though, is that I consider that if you apply the same rules of independence and impartiality of arbitrators, conflicts of interest, links between arbitrators and claimants, respondent states, counsel, you cannot ignore the third-party funder that is actually financing the claim. So my main idea is to say, well, if you have rules that are rules of relatively importance because it relates basically to the legitimacy of the arbitral process, that you apply towards counsel of claimants, it's very difficult to not apply exactly the same principle to the third-party funder. This, of course, hinges on one very important aspect, which Leo also mentioned, is that this implies that the financer, the third-party funder, has a form of control over the claim and how it's conducted, who is the arbitrator. Now, if you talk to third-party funders, they're not always very clear on this, but in practice, you do see that there's a very important influence on the choice of arbitrator, on the choice of counsel, on strategy. So they will nonetheless either very explicitly and directly, if not very more indirectly, influence nomination of the arbitrator, choice of counsel, and also the strategy. Now, why is this then a bit different in investment arbitration? I think there are a couple of reasons. The first one is that investment arbitration, as we all know, has relatively similar applicable law. There is, of course, a huge difference. We all know this. We discussed it in the previous event. But still, there are certain discernible principles that are actually the same throughout international investment law and arbitration. The second is that the awards are usually made public. The vast majority, there's still a couple of confidential, but still they're usually made public, which actually means that it's very easy to identify, well, very easy. It's a bit more easy to identify the particular vision of an arbitrator on a specific issue, either through majority decision or through separate and dissenting opinions that you very often have in investment arbitration. But if you combine these two, and the fact that you cannot in exit arbitrations bring any challenges at the enforcement level. You can do it through the internal annulment mechanism, but not at the enforcement level. I think it's very important that we have a strict regime of independence and impartiality of arbitrators, and that we avoid any conflicts of interest. Now, these three elements are specifically important in two scenarios. One is what we refer to usually as issue conflicts, where you have individuals acting as counsel and arbitrator in different cases. The second one is repeat arbitrators. That is this orange list in the IBA rules, which basically say that if you're appointed more than 3 times by the same party, it's actually potentially, it's an orange list, can be a problem of independence and impartiality. So these rules, if you apply them to counsel and to, in case of repeat appointments, to the state or the claimants themselves, it's very difficult if you again imagine that there is a certain form of control from the funder on the strategy, the choice of arbitrators, and also counsel, that you cannot, it's very difficult to imagine not to transpose exactly the same principles of conflicts of interest to the third-party funder, namely the question of repeat arbitrators, that you cannot be nominated 3 times consecutively by the same third-party funder. This is a matter of principle. I think in practice you see that many tribunals have actually followed this path. First of all, beyond tribunals you have the IBA rules on conflict of interest, the 2014, October 2014 version has actually also followed this idea and has expanded its definition of third party in a relatively broad sense, which includes every person that has an economic interest in the outcome of the dispute. So this includes actually third-party funders. In practice, you see also many tribunals, if they are aware of the fact, and this is of course the most difficult part, is you can only disclose third-party funding if you know that there is third-party funding. Otherwise, it's very difficult to have an order requesting disclosure of the third-party funding agreement. But you see that more and more tribunals are, based on the need to uphold the independence and impartiality of the tribunal, requesting disclosure of the funding agreement, not necessarily the precise financial arrangements, but one, the existence of an agreement, and secondly, the name and the identity of the third-party funder. And this is precisely to avoid the situation where you can have afterwards problems of conflicts of interest. Now, someone in Vienna also told me, yes, but at the end it doesn't matter, because if you don't know that there's a funder, you can never have a conflict of interest because no one knows. Now, I mean, from a practical perspective, it makes sense. From a principle perspective, I think it's it's flawed for 2 reasons. One is that independence and impartiality is not about actual bias, it's about appearance of bias. So we're not talking about whether or not the arbitrator that has been appointed 3 or 5 times by one state or one claimant of one fund is biased. It's about whether he or she appears to be biased. And this is precisely the point. It's not about actual bias, it's about appearance of bias, because it relates to the legitimacy. Secondly, there are a couple of cases, at least one important case, where it was actually disclosed afterwards because of a problem between the funder and its client, which means that during the arbitral proceedings, there was no knowledge of the third-party funding, but afterwards it became obvious because the funder and the client of the funder had actually problems, legal problems, that were brought to litigation. So it was made public. So it's not as if because you keep it secret, you can avoid any subsequent publication or public availability of the fact. Now, final point, and then I'll stop, is the potential negative effects. You see that you have more and more requests for security for costs by the other party, when that party knows that the claimant, for instance, has received funding. Again, there still is this perception that funding only is sought by claimant if they have or they're in a dire financial situation. I don't think it's necessarily the case. You have many examples of companies that seek funding. You mentioned the case of Quasar de Valores and Group Menatep. They're, of course, linked to a certain extent, the parties. There are many companies that within a certain group fund other companies of the same group. That can be for various reasons. It's not always the case that one party, the claimant, for instance, that sought financial assistance is in a difficult financial situation. But still, you do have this tendency of respondent states mainly requesting security for costs. And it was actually granted in one specific case, RSM Production versus St. Lucia. This is a very interesting case because you had a dissenting opinion from Gavin Griffith, who said that if you have security for costs, you should always order security for costs, which was not actually the reason why the tribunal ordered by majority with a dissent from Judge Nottingham. They didn't really consider the order for security for costs for that reason only. It was one of the considerations. Since then, of course, everyone, every state involved in investment arbitration confronted to a funded opposing party has made a request for security for costs. Now, two questions. One, can they do it? Of course. A tribunal can order security for costs. In the case of third-party funding, I don't think there's any opposition to this. The case of RSM is very different, I think, because they had actually brought already several claims before. And in certain cases, proceedings were discontinued because they actually failed to pay the necessary fees in advance. So it had actually a reputation of not meeting up to its financial obligations. And that's why they, at a certain point, this was also taken into account in the decision against St. Lucia. Should they do it? That's another question. I have no, to be honest, strong view on whether they should be the norm. I think it's probably, as the tribunal in St. Lucia did, RSM versus St. Lucia, it's a combination of various issues. I think it depends very much on the specific reputation, the situation of the other party, the amounts that are at stake. And I think probably the mere fact that you have third-party funding is not sufficient ground as such, I think, to order security for costs. It's probably one of the elements only in the discussion. Thanks.
Thank you very much. Now we hear from Rachel.
I have a presentation here. I'm not sure where it is.
It should be on the desk.
This one.
You have to unmute the screen.
Oh, it's.
Yeah. Sure. It should be
There's something here? All right. Where are we? Excuse me. Apologies for this delay while I get this. While I get this brought up. Nope. Excuse me. Where are we? There we go. I found it. All right. Thank you. Thank you to Frank. Thank you to Sebastian for enabling me also to be a part of this conversation, and to the rest of this panel for opening up this conversation a bit. I look forward to hearing also from Rusty as soon as I'm done. This is a new topic for me, and so when I approached it, I really had to think carefully about these ideas and how they fit together. And so there may be some overlap with some of the things that have been discussed, but I hope that this framework will enable you also to understand it better, and that it will facilitate our discussion afterward as we have questions. So I ask in part, and this is a reflection on the question that Frank asked at the very beginning of fairness, of what are we looking for in the reform of the investor-state dispute settlement system, and the question of justice for whom. It also refers to a main argument in favor of third-party funding, which refers to the access to justice, the concern that we have that people will have access to a just settlement of their claims. I think perhaps the beginnings have been discussed a bit. Third-party funding began first in domestic litigation and moved from there into international commercial arbitration, and as has been mentioned, has been surging up in international investment arbitration. And there are a couple of reasons for that have been posited. One would be that during the financial crisis, corporations and investors were experiencing a lot of financial difficulty and were seeking ways to pursue claims that didn't put them in a more difficult financial position, Another is more of a supply side argument that says that investors are attempting to seek other capital outlets, alternative capital outlets where returns are not correlated to traditional markets. Again, in the context of a financial crisis where traditional markets are not serving them well. But here are the main arguments laid out in favor of third-party funding. And third-party funding was a bit of a surprise to me in this context, given some of the asymmetries that have already been discussed in the whole system, in the system as a whole. But one of the main arguments is in favor of access to justice, that people would have, again, access to their claims being fairly decided before an impartial tribunal. A second very key argument in favor of third-party funding is this availability of that funding for both sides of the dispute. So again, it's an argument for fairness, but it's pointing out that this is not just a one-sided opportunity. This is an opportunity for everyone. A third argument in favor of third-party funding is that it produces a disinterested, a dispassionate, highly detailed assessment of claims better than even the parties themselves or their attorneys that are representing them. And then there are two related arguments in favor that say that third-party funding is just like other types of funding and should therefore be permitted and treated similarly to those other types of funding. And finally, in terms of its wider use, and this is of course more historical information, but its use in domestic courts, its use in commercial arbitration, points to the fact that it is a legitimate way to fund cases in general. So let's talk about this access to justice issue. And Leo, again, addressed some of this, but hopefully this will illuminate some of the evidence about whether or not there is an access to justice issue. This is a quote from the task force report, which Rusty was the head of that task force, or one of the co-heads. And this, I think, highlights that while the quintessential complainant in the context of third-party funding is a sort of impecunious individual or corporation, they're unable to they don't have the money to bring the case in large part because of the wrongdoing of the prospective defendant. That is actually not the norm in international arbitration today. That in fact, much of the focus of the litigation finance market is on the growing corporate utilization of funding by large, well-resourced entities who are looking for ways to manage risk, reduce legal budgets, take the cost of pursuing arbitration off balance sheet. So we're not, in general, for third-party funding purposes, we're really not looking at that impecunious client. The other evidence I want to point to is this idea that there are other funding availabilities, and this is something I'll get to talking about in a few moments, but the fact that there are other alternatives suggests that clients who are in need of money in order to pursue a meritorious claim have other alternatives. So third-party funding may not be the thing holding together this access to justice that we seek. So the second main argument, and evidence maybe that shows that that there isn't an equal use for this of this process, but while there has been anecdotal evidence of defendant states receiving funding, it has been very anecdotal. In fact, there were only 2 cases that I found in which this was the case. So one is the one we've discussed widely today, the Philip Morris case v. Uruguay, in which case civil society was mobilized in order to support Uruguay's case against Philip Morris. And in a second case, RSM v. Granada, in which the funder had a political interest in the states prevailing. So that's so it seems very clear that for the most part, what you have are investor claimants using third-party funding for their benefit in a system which we have already discussed this morning is highly asymmetric. And so this additional funding is essentially throwing a bunch of additional funding into one side of an already imbalanced system. A slightly less important note, proponents have argued that portfolio funding, which is one model of this third-party funding, portfolio funding could be used to fund defendant cases. That while we don't always have to have high return cases, we can include these defendant cases in our portfolio and therefore provide funding to more types of clients. It doesn't seem clear to me that that's the way portfolio funding and portfolio investments have been used in general. And so it seems that portfolio funding is really in order to match low risk, low return with high risk, high return cases in this case, as opposed to taking on pro bono or taking on very, very low return or no return defendant cases. So that's not a very strong argument in my opinion. There is a third thing I want to mention, and this is something I don't have a lot of evidence on, but someone mentioned to me that there's the concern that, and Leo made a brief mention of this as well, but state money, when you're talking about a state defendant, that's taxpayer money. And so if they were to make an agreement, assuming they were to be able to make an agreement with a funder, in which the funder received a return on some sort of benefit that the state gained before an investor-state tribunal, there is a possibility that this would be outside of the legal power of states to provide this return to a private funder because of their role as a sovereign state. All right, so what about this role as a disinterested, dispassionate assessment maker? That is, so funders argue, primarily funders have argued that it would be bad business to fund cases that are weak on the merits. And that seems like a basic business decision. We would never, why would we, on purpose risk our profits? And yet actually, Mick Smith, who is the co-founder of Colunius Capital, a funder in the context of domestic litigation funding in the US, states that the perception that you need strong merits is wrong. There is a price for everything. And this goes back to my discussion of portfolio funding in particular. Funders are constantly seeking out additional innovations in order to be able to fund lots of different kinds of cases. And this goes to this this bottom statement, which is this interconnectedness of the third-party funding community. So this is well established. People who are members of this community acknowledge that there is a strong interconnectedness between funders and attorneys and arbitrators and even user-funded parties in the system. This is acknowledged within the task force report, which is a broad-based consensus report in general. And that interconnectedness actually creates incentives without needing to imply any sort of bad faith on anyone's part, but it creates incentives that would seek to perpetuate the system, that would seek to increase the number of cases. And that fact in itself also speaks against the claim that it would be disinterested, that there would be a disinterested or dispassionate assessment of these claims. So what about these other funding opportunities? Third-party funding is functionally similar to other funding opportunities, and we have 3 examples of these sort of overarching examples here. If the other funding models are the same and permitted, then third-party funding should be permitted as well. And in each of these models, the funder can provide non-recourse funding with the promise of a return if the complainant wins, and that's very similar to third-party funding. In a corporate or equity financing case, you have a related corporation or part of the corporation funding a case for a smaller portion of that corporation often, So in that case, there is the same model, but in that case, the financier is related to the complainant. And so as Eric was pointing out, these issues of conflicts that might come up are just not going to be an issue because that is already discoverable, that is already has to be disclosed in the international arbitration context. In insurance, there's both before the event insurance, which is not the same exact model, but also provides funding, and then after the event insurance, which is often a corporation who is in the middle or has initiated a claim and needs funding for that claim, in that case, it is offering the same idea. However, the key differences between insurance and third-party funding, as we are discussing it today, is that insurance is often at a much lower cost to the funded party, and insurance is a reimbursement at the end of the case, usually. At least that's the common structure, rather than a day-to-day financing for things that can come up. So it is a little bit different in its structure. The final one is something many of us may be more familiar with: contingency fee arrangements. For similar reasons to the corporate and equity financing, is also immediately discoverable. We don't have the same issue of secrecy that could create conflicts of interest difficulties. So what about the uniqueness of investment arbitration? I actually don't want to say too much about this because this is something that Leo discussed pretty extensively. But just to remind you that one of the reasons that this is so one of the reasons that we're addressing this in the investment arbitration context is because of the role of states as sovereign entities and their special status as opposed to commercial litigators in commercial arbitration. So from here, what I want to say, what I discovered as I was looking into this is that there is actually just a lot of unknowns about the impacts currently, about the future use of third-party funding, about who ultimately benefits from third-party funding. And since we've already had an extensive discussion on conflicts of interest, I won't say anything about this except to say that we have already sort of generally agreed, those that are apart, and by we I mean those that are in the system have already come to sort of a general agreement that the existence and the identity of a third-party funder should be disclosed. And that is not actually all that controversial, but has been seen to be important for many people involved. The only question is who should disclose it. And I won't actually get into that too much right here. But what I want to say is that there's actually a larger scale interest in disclosure, and it's not in just the disclosure of the existence of third-party funding or the identity of the third-party funder, but there's actually an interest in disclosing key provisions in that funding agreement, and that is something that is going to get a lot of pushback if you try to go into the system and regulate funders in that way. But here are some reasons that I think that's important. One is sort of a general interest in transparency, and this is evidenced by the 2006 modification to the ICCA arbitration rules in favor of transparency and new transparency rules in the UNC rules as well in 2013. There is a general trend towards transparency, and in favor of the legitimacy of the system as a whole, we ought to be seeking that in every part of the system, and that includes third-party funding. So that's more of a general statement, and I don't think that gets us all the way there. But the second thing the second argument that I want to make in favor of more expansive disclosure at the arbitral level is this repeated theme that is there is just so much unknown, and I just mentioned that there's so much unknown about third-party funding in the context of international investment arbitration. Excuse me, sorry. The proponents speculate that third-party funding is going to promote greater and much-needed investment in developing countries because investors will feel more comfortable that their rights and interests will be preserved. That's a very solid argument. Critics speculate on the other side that it will increase both the cost and the amount of litigation, leading to draining state balance sheets and ultimately a regulatory chill. Until we have data, we don't know the truth of either statement. Either could be true and both could be true in different contexts. And so in order to gather this data, we need to not only know the existence and the identity of third-party funders, but also the general structure of these funding agreements, the financial situation of the funded party perhaps, as well as some of the common provisions that govern control over the case, as Eric mentioned as well. So these are things that we need to know in order to be able to make better decisions in the long run. Finally, I want to push a little bit further. So despite the fact that third-party funding is currently accepted in the realm of international investment arbitration, and critics actually that have called for it to be banned, especially when it first came to light, have been really unable to, quote, move the needle in terms of making practical changes. And but that doesn't mean that we ought to accept third-party funding is here to stay forever. And here's my main argument for that. The investor-state system, the reason we're here today is because the investor-state system, investor-state dispute system, and investment agreements generally are approximately 50, 60 years old, and as a result of that amount of data that we have gathered, the experiences that we've had with those treaties and with that arbitration, we now know what the weaknesses are. We now see where the reform is needed, and to say that it's here to stay is to in a sense give up. And instead, I want to urge us to, for now, regulate if that's what we need to do. It's in existence. It's what's happening. And in that regulation that we need to seek, we need to have a long-term view to pushing the envelope further where the evidence suggests that we ought to. As with any legal practice or institution, we ought to welcome ongoing scrutiny, which pushes us to provide greater justice, as Frank was mentioning earlier, greater transparency, greater consistency, and the expansive disclosure is one way to take a step in that direction. Thank you.
Now we'll hear from Rusty Parks. Those of you that came in late, Rusty's the co-chair of this task force project that currently addresses these issues.
Thank you very much. Rachel, did you want to turn your machine off? How do you do that? All right. Do we turn that off there also? What should you? Because this is, how do you do that? All right. Somebody here has technological skills. Those of you who know a bit about French history or who have read Shakespeare will recollect that today, the 25th of October, is the anniversary of a very famous battle in what's sometimes called the 100 Years' War between Britain and France. It was 1415, the Battle of Azincourt. And this battle was made famous in a play by Shakespeare called Henry V. And that play has been put into movie versions several times. And in that play and movie, there's one famous scene where the British are about to go into battle against the French, and the Earl of Westmoreland says to King Henry V, "But sir, we are few," worrying that they're going to lose the battle. And Henry V answers, "We few, we happy few, we band of brothers." And Henry V is happy, the king is happy that they are few because it means more honor for each of those soldiers who's involved in the battle. And of course, they eventually win the battle in 1415, but they lost the war 15 years later when Joan of Arc came out of the shadows and drove the British away. Now, this phrase, "we few, we happy few," comes into mind in thinking about discussions of investor-state arbitration, because there are, in fact, very, very few people who are honestly interested in discussing the merits of the subject. This subject has become a political football. It's become somewhat of a Rorschach test. I think most of you know what a Rorschach test is. It's a psychological projection test where someone looks at a black spot, and the black spot might be a spider, or it might be a beautiful woman, or it might be a castle. And what you see in the black spot tells you a lot about who you are. And people who look at investor state funding tend to see things in it that are related to a particular political perspective, just as people who look at arbitration in domestic contexts tend to see things from a political lens. You probably read in the newspapers that yesterday there was a vote in the US Senate, 50 to 51, with the vice president casting the deciding vote, for a measure that would limit class actions in the United States. And the newspapers that tend to be part of the liberal press, like the New York Times, have come out against this vote. If you were to take at least this is my quick read of the arguments that I saw last night and early this morning, if you were to take the arguments that are made by the liberal factions in the United States, if you will, the leftist factions talking about it in European terms, those arguments in favor of class action, but substitute the word third-party funding for class action, because in fact class actions are a form of third-party funding, you would get the very same debate you are getting in connection with investor-state arbitration, third-party funding, but the left and the right would be reversed. In the United States, the right tends to be against class actions, the left tends to be for them. In international relations, the left tends to be against third-party funding and in favor of, the right tends to be in favor of it. In any event, with that general comment on our topic, let me go to the devil in the detail, because when one talks about regulating third-party funding, there are what I would call the three musketeers of third-party funding regulation. And they're really, as those of you who know the Alexandre Dumas novel, The Three Musketeers, there are actually four musketeers. There was D'Artagnan, who was added to Athos, Porthos, and Aramis. And there are really four. The first is the question of disclosure. And that's been dealt with a fair amount by the previous speakers. Most people now reject the notion that what you don't know can't hurt you. If there is an arbitration in which a partner of a law firm is serving as chair and one of his or her partners is representing a financial group that is funding one side or the other, that ought to be disclosed. And that would be the first of the three musketeers. The second of the three musketeers has to do with costs. And in terms of costs, there are really two issues. One is whether there can be an order for security of costs. And another issue is whether costs can be reimbursed at the end. In other words, the general rule outside the United States, the general rule of litigation and arbitration is that the loser pays. Can the loser be required to pay the winner's third-party funding costs? Now, there's another issue that is starting to be discussed in addition to these two questions concerning costs, and that is whether the tribunal can order one side or the other to make a disclosure of third-party funding. And that has, in fact, come up recently in a number of ICCA cases, including one where, in fact, the state was funded by a third party, and the tribunal's disclosure of the tribunal's order to disclose the third-party funding ultimately led to a challenge to all three arbitrators by the state. The challenge was rejected, and the arbitration goes on. And I don't want to say too much about that because I'm chair of the tribunal, but it has been in the news. And that would bring then to the third of the three musketeers, which is a question of privilege. People don't often talk about privilege in the context of third-party funding. But there's something that Anglo-American lawyers know, which is called common interest privilege. For example, if you have a policyholder and an insurance company and they have a common interest, there is no waiver of privilege because documents are exchanged between the two. And this is, I think, an unexplored area, which would be good for anyone here, a graduate student who's looking for a subject on which to do some scholarship. The whole question of third-party funding and privilege, common interest privilege. Now, a word of caution here, outside the United States, the notion of privilege doesn't have the United States and England, I should say, common law countries, the notion of privilege doesn't have the same connotation. My understanding is that in most continental countries, or countries that follow the continental model, there is professional secrecy, meaning the lawyer cannot make a disclosure, but one does not have the same notion of privilege attaching to a particular document. But certainly for someone from the Anglo-American tradition, this would be an excellent subject for research. The fourth musketeer, the D'Artagnan in the array of personages, relates to so-called best practices. There are lots of people now who are writing about best practices in third-party funding. My own tendency is to avoid the word best practices. As a fellow of the College of Commercial Arbitrators, I'm not terribly comfortable with the fact that they put out a book called Best Practices, because in fact, there's a lot of leeway in international arbitration for different types of practices. There might be bad practices, there might be good practices, but it's often hard to say that there is a best practice. I often say when someone introduces me as an expert in international arbitration who knows about the best practices, I'm not an expert. I might be a specialist in that it's what I do to make a living. But the last time I was an expert was 43 years ago when I did my first arbitration. And since that time, I have stopped being an expert because I see how many different ways there are to do things. Now, those who are interested in the task force itself should probably address themselves not to me, but to two very fine people who deserve mention here. Catherine Rogers, who is a professor at Penn State and has another position at Queen Mary, and Stavros Brikoulakis, who is at Queen Mary in London. Those two co-chairs have taken on themselves the lion's share of the work. And I think that probably at this point, that's what Frank wanted me to say, is that right?
Yeah.
And so I should probably sit down and leave it to questions.
Great. Thank you. Thank you, Ryan. So, because we are recording this, I would ask your patience as Alex gets the microphone and then brings it to you to be sure we have clarity of your comments for the public comment section. And I'll probably take a few questions at a time and then let the panel address them. So Alex, as soon as you're ready. So, show of hands. Sonia and let's start with Sonia.
Thank you. This is for whomever can answer this on the panel. Maybe Eric is the best person, but I'm just wondering, with respect to publicly listed companies, wouldn't a third-party funding be disclosed somewhere in their securities documents for shareholders? And if so, then I understand different stock exchanges, different countries would have different rules, so it's probably not a substitute for having a more centralized, consistent debate about this and rules, but does that also preempt the issue to some extent?
Any other questions, or should we proceed? Eric?
Do I have to?
No, it's your mic.
Yeah. Okay. Yeah. I mean, this is why in several cases, claimants actually make an official statement confirming that they have sought third-party funding. In others, you probably can spot it indeed in the documents, but claimants then have a tendency not to be very explicit about it. But you can actually retrieve the information. If indeed if you take the examples of Belgium, for instance, you can find all this information because you have to state at a certain point all litigations above a certain point you're involved in. And there you see also, you have to be able to see whether indeed there is funding. But people generally, yeah, I mean, it's not always easy to find out, but if you want, you can probably find it out relatively easily. But you have to go and look for it. And that's the... But there are a couple of other companies, small and medium enterprises, that very often also look for third-party funding, and they will actually be less explicit about it. Also because they're small and medium enterprises, they probably less than big companies have this reputation of being financially stable. And so they're much more careful in being very explicit and open and public about third-party funding that they have received. Yeah.
Yes, back here.
Thank you for your presentations. I may have missed this point, but I was wondering if there have been cases where third-party funding has brought about issues of bias and conflicts of interest. Have there ever been cases of this, or is this just one of the sort of pain points that may be created as a result of third-party funding?
Rusty, or can you comment on that?
If I understand, you're asking whether or not there are instances where the disclosure of third-party funding has resulted in a finding that one of the arbitrators is biased. Is that your question? Because I wasn't really sure to get what it is that you were asking. Are you asking whether there have been instances where a disclosure has resulted in the disqualification of an arbitrator?
Not necessarily the disqualification, but just the claim that an issue of bias or conflict of interest was raised by one of the parties.
There are cases where the issue has been raised. To the best of my knowledge, there are no cases where a disqualification has occurred.
Yes.
Yeah, thank you for that interesting discussion. This is not my area, so perhaps my question is misguided. But if I remember from Alexandre Dumas, D'Artagnan was the most unpredictable of the musketeers, which is why I liked him. Yes. And so my question is the best practices. I wanted to ask if you could elaborate a little bit on that, why you thought that was not a good way to regulate third-party funding, only because I work in areas of regulation and trade and investment, and best practices seems the way that regulation is going in that direction, right? It's sort of away from government regulation towards best practices and sort of input from the private sector. So I was interested in learning a little bit more about your skepticism in that regard.
Well, perhaps my comment was made poorly. It isn't so much that it's wrong to have good practices and bad practices set out. What seems to me a little bit objectionable is to say that one particular practice is the best and that the others are bad. That anything that is not the best is bad. Because in international arbitration, you have a very broad spectrum of fact patterns that can arise. For example, talking about privilege, there's a dramatic difference between the notion of privilege in an Anglo-American context and professional secrecy in a continental context. And what might happen is that the Anglo-American lawyers who write the so-called best practice forget that half of the world does it differently, and that the notion of professional secrecy requires a different approach. Because in fact, in continental countries, generally the duty is on the professional, the lawyer. There's no special status that attaches to a document. And so there's no doubt that there are some bad practices and some good practices. My allergy to the term best is perhaps an allergy to people who say we're experts and we know what is best for everyone in the world, when in fact there is a broad spectrum of activities that are acceptable. Does that reassure you that I'm not in favor of bad practices?
Sorry, if I could just clarify, I didn't interpret it as in favor of bad practices, but I was wondering if perhaps there was some common practice that was developing or evolving that could influence the practice of third-party funding.
Well, there certainly are practices that are evolving. One of them is disclosure. Generally, people think today, unlike what they thought, say, 10 years ago, that if you have, in my example, a partner of a law firm who's chairing a tribunal, and her partner or his partner is representing a financial group that is funding one of the two sides, that ought to be disclosed. Now, it may be that if it was not disclosed, the chair could say, gee, I didn't know about it, so my decision was impartial, I was independent. But certainly, there is a bad odor to the arbitration if it is found that the same law firm is supplying one partner to chair the tribunal and one partner to advise the funder of one of the two sides. So that would be an example of a practice that is evolving. And although there are still some people who will say to me at cocktail parties or luncheons, you know, what you don't know can't hurt you. And they'll say it in French or they'll say it in German. It's something that a lot of people believe still. My sense is that is the minority view now. And it's the minority view because of the International Bar Association rules, the ICCA task force, and a number of other pronouncements that have been made. But you see, things are not so simple. For example, we talk about the independence of arbitrators. And it's something which is very important in mainline commercial arbitration and in mainline investor-state arbitration. But there are some arbitral systems where the arbitrator is not necessarily expected to be independent. There is a case which is public. It's a case decided in England in February. It's called HVL. And it was the 3rd of February, if any of you are interested in this case. The H and L are simply letters given to represent parties in the arbitration and an arbitrator. In that case, the chair of an arbitral tribunal, who had been appointed by the court over the objection of one of the two sides, it was an insurance case, and the policy holder, the insured, had objected to the appointment of this particular barrister as president of the tribunal or chair of the tribunal because he had a long history of representing insurance companies. In that case, the chair accepted appointment in another arbitration by the very same insurer represented by the same firm of solicitors in an event arising out of the same incident, which was the Deepwater Horizon oil spill, in the same type of insurance dispute. And the High Court said, you have a problem with that? We know this barrister is an honorable man. We've known him here in the English community for many years. He's 80 years old. He's about to retire. We will not require that type of disclosure. And they actually talked a little bit about the International Bar Association rules and said something equivalent to let the IBA F off. You know, we don't really have any truck with what the international community has to think about this. Now, that narrow community of insurance arbitration in London apparently has a very different view of best practices from that which would be prevailing in the United States, France, Switzerland, Germany, almost everywhere else.
So let me, oh, go ahead, sir.
Well,
You want to wait just till the mic?
Oh, sorry. Just a quick thought on the different rules that apply to different arbitration settings and how do you see any potential harmonization when some arbitral institutions have actually openly admitted that one of the comparative advantages, the flexibility to allow different practices, less transparency, or in some cases even more flexibility for allowing this type of processes. In other words, I think when we think the institutional setting that we are facing, we always have to think what's the alternative. And I always use this example. People talk about Brazil not having bilateral investment treaties, right? But Brazil is also the single largest state, or Petrobras, the single largest respondent in ICCA arbitration, or one of the single largest one. Right? So it's acting as a substitute for cases that could be investor state. Right? So in some way, what are those incentives that are created if we think of regulation in this fragmented area? And whoever wants to jump in.
Yeah. Okay. Yeah. It's interesting. There's also a lot of competition between ICCA, PCA. I mean, one of the reasons why you go to the PCA is also that it's probably more easy to have secret proceedings, no information. There is a lot of competition, and they're also very careful, of course, in adopting regulations to this effect. But that's why I'm also skeptical generally about regulation, because I think it's very difficult to imagine a situation where this will also be generally accepted throughout. I mean, you have with the exception again of the conflicts of interest. I think this is, as Rostil said, you still find people opposing this, but generally everyone accepts this. But yeah, I think this competition will also probably only increase in the years to come. So that's why I'm not a big fan of regulation. I don't see how you could actually achieve this and have all institutions gather around a single idea of how this should be, if you call it best practices or something else, should be regulated. Because indeed you have, ICC has also very different interests than ICCIT has. I mean, it's obvious. Yeah. So I don't fully answer your question, but that's the only thing I can say now.
So let me actually build on that and exercise my prerogative as chair to pose a question to everyone on the panel, which is, we've been talking about a range of techniques that are not new techniques in the lawyer's toolkit. Talk about disclosure, conflict of interest, best practices. But there's at least 3 different ways in which we could talk about techniques like that. One would be in the sense that if we are in an environment of insufficient knowledge, we're not sure what the best approach would be to regulate something. Well, let's adopt some strategies that will help bring out the necessary information and avoid some of the more obvious issues. A kind of a pragmatic interim way to use these techniques. Another approach would be to use techniques like best practices and disclosure, because we think that those are exactly the right tools to address the regulatory challenges posed by a set of issues. So it's not simply a sort of interim strategy, but it's a strategy tailored to, we say, if we adopt this approach, we will address the challenges posed by this phenomenon. And there's another approach to using techniques like disclosure, best practices, which really, in a way, could be characterized as distracting the regulatory effort away from the key structural issues, which are not going to be touched by approaches like best practices and disclosure. So these are just 3 different ways to characterize how these techniques are coming up or can be talked about. And I wondered if you'd all comment on that with respect to this issue of third-party funding itself. Just start, Eric. Go
Yeah, no, but maybe we should.
Or Leo, you want to start with Leo?
Right. So from a very academic point of view, and not a very practical one, I would say that once again there's a difference between international commercial arbitration and international investment arbitration. And in commercial arbitration, certainly best practices and reform within the system through kind of a a regulation that's not too strong like we've seen in Singapore or Hong Kong recently. I think that can be helpful to tackle some of the problems. In investment arbitration, I would say that it's a more systemic issue, and therefore a more general reform is needed in order to tackle TPF and the ISDS system and its legitimacy issue.
Rachel?
Yeah, I mean, but because of what my presentation was already on, it's clear that I think that it's useful to use these strategies in order to create information that we can then act on later on. You know, it's, again, because of our lack of information, it's not clear that we have the right tools currently to address all of the issues that third-party funding might create. I also think there's, and this might be revealing a bit about myself in the sense of the Rorschach test that Rusty was talking about earlier, but when I come to this, I see some real fundamental difficulties, and Leo spoke to these in more depth earlier, but some real fundamental difficulties with the way that investment treaties and investor-state dispute settlement, and then relatedly third-party funding is set up in a really asymmetric way. And I think it's possible that by talking too much about the ways we mitigate difficulties that we're facing, or that we take care of immediate sort of conflicts of interest, for example, that we might be distracting from a larger discussion. And it's hard to have that discussion when we're talking about something that is currently practiced and accepted by practitioners. So I think that's a real danger here and probably in other areas.
Yeah, no, I don't have much to add actually. I think it depends. I will talk about this later. It depends, of course, how you look at this. I mean, if you talk to people, public international law professors, they think it's simply outrageous that someone would actually finance a claim against the state. So there are indeed broader questions that are not addressed by the specific regulation. But I think this is more on the policy level. I think if you look at it more on the level of what can you easily regulate, I think you have to limit it to questions of disclosure. I think the rest is more something you can maybe include in treaties, for instance. But it's very difficult to prohibit third-party funding. The result of that will be that you will still have it, but you will no longer see it.
Well, I think that one of the points which Rachel made, of course, and others have made, is that we need to have information before we come up with any good versus bad practices. Another thing, though, is that we do need to be aware of our own predispositions, because often someone who is writing a manual on good practices or bad practices will have presumed his or her own conclusion ahead of time. I mentioned in the beginning of my remarks that what's always, to me, very impressive is how few people actually look at investor-state arbitration in a dispassionate way. Usually someone starts out thinking it's good or it's bad. And right now, the chief spokespeople for both the left and the right tend to think of it as bad. Trump attacked it at the United Nations. He attacked unaccountable international tribunals, and there he was referring to NAFTA tribunals. Elizabeth Warren has used the same language. They both come into this with the presumption that unaccountability is a bad thing, whereas in fact, you might say that unaccountability is just another term for independence and impartiality. Because once a tribunal is accountable, the next question is accountable to whom? To the claimant or to the respondent? Now, these types of notions of accountability vary from age to age. Often people cite the so-called Alabama arbitration in 1872 as the beginning of international arbitration. Probably some of you have read about that case between the United States and Britain after the U.S. Civil War. There was an arbitration by the United States against Britain. because Britain had allegedly, and with one ship it was found to be correct, the Alabama. With two others, it was found to be correct, the Florida and the Shenandoah, by a majority, but not unanimous. Britain was found to have allowed ships to be built in Liverpool that then served the South, the Confederates, to go around the world attacking merchant vessels of the North. And Britain had to pay 15.5 million in gold, which today would be about 220 billion. That award, the Alabama Award in 1872, is often taken as a paradigm of international arbitration as a peacemaking mechanism, because in fact it probably did prevent the United States from invading Canada. Senator Sumner, who was, as in Sumner Tunnel, who was the senior senator from Massachusetts, said to the Brits, if you don't pay up, we're going to invade Canada. And arbitration resolved that dispute. But when you look at what the arbitrators were actually doing then, Charles Francis Adams for the US and Alexander Cockburn for the British, they were taking instructions from their governments. It was not an international arbitration as we know it today. Today it would be considered quite outrageous for the arbitrators to be having conversations with the lawyers. But that was a beginning. And it wasn't a best practice, but it was a practice that was better than the alternative, which would have been war between the United States and Britain. So one has to, again, getting back to this notion of good practices versus bad practices, one has to realize that things are evolving, and hopefully, and this I guess is the point that was being made in response to the question that was posed to all of us, hopefully those who are drafting the good practices and bad practices will try to start without presuming the conclusion. Because if you do start with the conclusion that third-party funding is very, very bad, you're going to come up with one set of rules. If you start with the presumption that third-party funding is always good, you'll come up with another set of rules. But it might be that it's good in some cases and not so good in other cases.
Maybe just to follow up on that, it's interesting, we haven't talked much about the report itself as a document, that the chapter at the end on third-party funding reads to me stylistically very different than the other chapters, in part because it seems that there was this strong division of opinion within that part of the project about just what approach to take. So I'm wondering, not asking you to reveal any internal workings, but if some of that Rorschach test that you're talking about was also at work in the task force on the ISDS element of third-party funding.
You certainly had a divergence of views.
Yes. Any other final comments before we wrap things up? Yes, please.
Thank you. I have a question, a very general question, because of China's latest development in third-party funding. Since there is no regulations or legislation in China regarding to the third-party funding, in domestic China, and now last month, the end of September, CETAC, China International Trade and Economic Arbitration Center, which is the largest international arbitration institution in China, has released an arbitration rule, that is an investment arbitration rule. And Article 27 of that rule regulates about third-party funding. That is the first time in China have a word about third-party funding. However, it is regarding to international investment arbitration. So my question is comparatively general. That is, in your standing, do you have any suggestion for China how to introduce third-party funding into the domestic market in China, especially for the arbitration industry? And maybe we have to divide to commercial arbitration and investment arbitration. And also, we may regulate the arbitration, the third-party funding industry through legislation that is by law, or we have a self-discipline mechanism like the ICCA have illustrate some kind of guidelines to rule or instruct the practitioners to how to perform the third-party funding. So I'm looking forward to have seeking some suggestion regarding to how to regulate about third-party funding. Thank you.
That seems like an invitation to send the report to China.
Well, if Mr. Hu wants to send me an email, I will send him a copy of the report and also a copy of the IBA rules, because in IBA General Standard 6 and General Standard 7, the IBA rules also have something to say about this.
All right, I think we're coming to a close now. Please join me in thanking the panel very much.